Good morning, this is your Kelso Report for Monday, July 2nd. I'm your host, Clark Kelso. We begin with a Ninth Circuit case involving review of magistrate decisions. Now, it's well established that if a district judge is inclined to depart from credibility findings of a magistrate judge that were favorable to the defendant in a criminal case, he may do so only after holding a de novo evidentiary hearing. That protects the defendant's rights to due process. In United States v. Toms, the Ninth Circuit was faced with the other side of the coin, where the district judge was inclined to reverse credibility findings of a magistrate judge that were favorable to the government. The government insisted on exact parity and demanded a de novo evidentiary hearing. The defendant, of course, resisted, arguing that the government, unlike the defendant, does not have a due process right worthy of protection. The Ninth Circuit rejected both extremes and held that a district court abuses its discretion when it reverses a magistrate judge's credibility determinations made after receiving live testimony and favorable to the government, without viewing key demeanor evidence de novo, except where the district judge finds that the magistrate judge's credibility determinations had no legally sufficient evidentiary basis. In other words, there is a very strong presumption in favor of holding a de novo hearing, but such a hearing is not required where there was no evidence to support the magistrate's findings. Next, an interesting remedies case. The Ninth Circuit. The defendant contractor was responsible for negligently setting a fire that burned roughly 18,000 acres of the Angeles National Forest in Southern California. In United States v. CB&I Contractors, the Ninth Circuit had to consider whether the United States could recover damages in its suit against the contractor, measured in part by the intangible harm to the environment, representing harm to certain endangered species, the destruction of historic sites, damage to soils, and lost recreational use. The defendant did not challenge its liability or the jury's award of roughly $7.6 million in fire suppression, emergency mitigation, and resource protection costs, but it did challenge the jury's additional award of $28.8 million in intangible environmental damages. California statutes clearly provide that a property owner whose property is injured by fire may recover any damages to the property caused by the fire, and California law generally permits compensation in torts for all harms that a plaintiff suffers. And in particular, California courts have long recognized that property damages may include intangible harm to the affected property, and damages can be measured by criteria other than diminution in market value. As a result of all this law, the Ninth Circuit affirmed the jury's award of damages for intangible environmental harm, an important remedies case in property damages. Next, we turn to pension reform. The city of San Diego had cut a new deal with its represented employees, which modified certain benefits for employees hired after 2005. But the city did not actually amend the applicable ordinance reflecting these changes until 2007. Employees hired between 2005 and 2007 brought suit, claiming that the 2005 deal was ineffective until the statute was amended, and that a statute cannot retroactively diminish pension benefits. Recognizing that benefits ordinarily cannot be changed retroactively, the 4th District nevertheless held that where the statutory change merely implements a prior collective bargaining agreement, the terms of that agreement can apply to employees hired after the agreement but before the effective date of the amendment to the ordinance. Next, a case involving sex offender registration. The defendant in People v. Aragon was convicted for willfully violating the registration requirements of California's Sex Offender Registration Act. Under the Act, a convicted sex offender must register in the county where he resides, or, if he does not have a residence, where he is located as a transient. So he's a resident or he's a transient. For purposes of the sex offender registration requirements, residence actually includes a recreational vehicle that can be located by a street address. So if you park in front of a house, well, then you're actually in a residence. A sex offender must also re-register within 5 working days if he moves to a residence after being a transient. Well, you guessed it, that confusion created a problem. The defendant lived in a travel trailer that was parked on the street in front of his brother's residence. During those months, the defendant actually went to the Sacramento Sheriff's Department each month to register, but instead of reporting the street address, he reported he was a transient. The failure to report the street address was the basis for a conviction. In a very interesting decision, the 3rd District held that because he did not know that his travel trailer became a residence when he parked it in front of his brother's house, he could not be convicted of willfully violating the registration requirements. Emphasizing the willfulness element, the 3rd District reversed the conviction. As the court noted, willfulness implies having a purpose or willingness to fail to register. And if the defendant did not know that his travel trailer constituted a residence, he cannot be punished for willfully failing to register the address, particularly when he was registering every month as a transient anyway. So there was no intention at all, or no evidence of any intention at all, to violate the law. Next, a case involving rehabilitation benefits. The petitioner, who suffered from cerebral palsy, applied to the Department of Rehabilitation for full reimbursement of his tuition at a private college associated with pursuing a degree in video game art and design. The department awarded petitioner tuition assistance, but only at the state university rate. Petitioner appealed, and in Hoyt v. Department of Rehabilitation, the 1st District agreed with the department. The petitioner had argued that Section 7155 of the California Code of Regulations provides that the department may reimburse at the private college rate if it is clear the client's training needs can be better met by a private institution. Noting that the regulation uses the word may and is therefore permissive only, the 1st District concluded that the department's only obligation is to fund training at no more than the rate charged by a public institution if it establishes that the public institution is sufficient to meet the client's training needs and vocational objectives, regardless of whether the private institution may offer a training program that is better in certain respects. You don't get the Cadillac program, in other words. Next case involving criminal sentencing. Common sense was the rule of decision in re Lira, where the 6th District concluded that when a prison inmate remains incarcerated after the governor has erroneously vetoed a decision to grant parole by the Board of Parole Hearings, that period of continued incarceration is not lawfully served, and the inmate is entitled to custody credit against his term of imprisonment, which includes the prison term and term of parole. The court also concluded that if the inmate has been released on parole prior to a determination that the governor's veto was erroneous, the inmate, now parolee, is entitled to have that custody credit applied to reduce the term of parole. It is a sign of the absurd complexity of our sentencing laws that it took the court 47 pages of reasoning to reach this common sense decision. And that's it for today's Kelso Report. Have a great day in the law.